3, 2, 1, start. Shorn of unnecessary details. The facts are that the petitioner was initially appointed as a graduate engineer within bracket trainee in the year 1985 under the West Bengal State Electricity Board, restructured and reorganized to be the West Bengal State Electricity Distribution Company Limited within bracket hereinafter referred to as WBSEDCL bracket close stop. Subsequent thereto, he was permanently appointed in the post of assistant engineer within bracket electrical in April, 1986, and he was elevated to the post of superintending engineer in the year 2007. Stop. He was served with an order of suspension dated 29th April, 2008 issued by the respondent number 5, and thereafter he took a decision to resign from his services and wrote a letter to that effect on 30th May, 2008. But by a letter dated 10th June, 2008, the petitioner was intimated that his resignation cannot be accepted due to non-completion of the disciplinary proceeding. Stop. In the midst thereof, the petitioner was issued a charge sheet dated 28th May, 2008, to which he replied on 20th June, 2008. But the said reply was not found satisfactory, and accordingly by a memorandum dated 27th June, 2008, the respondent number 5 appointed an inquiry officer who conducted an inquiry in which the petitioner duly participated, and upon conclusion of the same, an inquiry report was filed on 26th December, 2008. Stop. The petitioner duly replied to the said inquiry report on 24th January, 2009, and subsequent thereto a second show cause notice was issued on 28th March, 2009, and the order of punishment was ultimately passed on 2nd June, 2009. Stop. Aggrieved by the said order of the disciplinary authority, the petitioner preferred a statutory appeal, but the same was also dismissed by an order dated 10th November, 2009. Stop para. Records reveal that the writ application was admitted on 18th April, 2010, with a direction towards exchange of affidavits. Stop. The respondents failed to file the affidavit in opposition within time, and by an order dated 26th November, 2010, extension was granted to file such opposition upon payment of cost, and that by an order dated 15th March, 2012, the court directed the respondents to produce documents to show as to whether the contract was awarded to Messrs. Secure Meters Limited within bracket hereinafter referred to as SML bracket close stop para. Mr. Aurobindo Chatterjee, Lane, senior advocate appearing for the petitioner, submits that a perusal of the charge sheet would reveal that the charges are twofolds. A. The writ petitioner attended a presentation at New Delhi on 17th April, 2008 without having any permission from the higher authority. Semicolon. B. The writ petitioner was availed the hospitality of SML and his airfare from Kolkata to New Delhi on 16th April, 2008, and return journey from New Delhi to Kolkata on 17th April, 2008 was borne by SML when he had official dealing with SML, and accordingly he exposed himself to pecuniary obligation under SML. Stop para. According to him, no evidence has been laid to bring home the alleged charge to the effect that the airfare of the petitioner was borne by SML, and that accordingly the petitioner exposed himself to a pecuniary obligation. Stop. There is also no evidence on record to establish that the petitioner's conduct amounts to lack of integrity, breach of discipline, and violative of regulations 38 and 40 within bracket 2 of the West Bengal State Electricity Board Employees Service Regulations within bracket hereinafter referred to as the said service regulations bracket close as adopted by WBSEDCL, and that the petitioner was guilty of breach of discipline and negligence in terms of regulation 16 within bracket B, 61 within bracket D, 61 within bracket D, and 61 within bracket P of the said service regulations. Stop para. Mr. Chatterjee further argues that the inquiry report is based upon surmises and conjectures and the observations of the inquiry officer to the effect that the petitioner was in hand and glove with SML, and that the non-payment of airfare to SML in advance by implication is a kind of borrowing money from a private organization and absolutely unfounded. Stop. There is no evidence whatsoever that the petitioner availed hospitality by SML, and the inquiry officer travelled beyond the charge sheet and made a desperate attempt to establish that the petitioner availed hospitality by SML. Stop para. According to Mr. Chatterjee, there is no evidence which links the petitioner with the misconduct alleged against him, and that evidence, howsoever voluminous it may be, which is neither relevant in a board sense nor establishes any nexus between the alleged misconduct and the charged officer, is no evidence in law. Stop. The mere fact that the inquiry officer has noted in his report that within quote in view of the cast iron, determinative, corroborative, conclusive and incontrovertible oral, documentary, and circumstantial evidence, I am driven to the irresistible conclusion that the prosecution has been able to substantiate the charge as mentioned above beyond reasonable doubt against the decode, does not in principle satisfy the rule of sufficiency of evidence, and that the inquiry report is absolutely perverse. Stop.